And we're barely 3 seconds in and this hearing is already off the rails. This is one of those moments where you can instantly tell the judge's patience is going to be tested today. Listen closely, this tone right here sets the mood for everything that follows.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Yes.
Thank you. Prior to going on the record, we discussed the pre-admitted exhibits, which would be admitted at this time. Petitioners 1 through 19 are admitted. Respondents 1 through 53 are admitted. And this is a report for de novo appeal filed by Ms. Butt. And it is the request of a de novo for the associate judge's report regarding the granting of respondents' special appearance. Is that correct?
That is correct, Your Honor.
Okay, pause for 1 second. This is where things get legally dense. The judge is clarifying exactly what this hearing is about, and that matters. Courts hate going outside their lane, so watch how she shuts down anything that's outside the narrow, de novo appeal issue.
Judge, I think that it encompasses a little bit more. I think that the de novo talks about the denial of the emergency jurisdiction request. And within that, I think there was a denial of the protective order because Judge Lee heard all of that.
That's not what's on here. What I'm reading is the respondent special appearance be granted. This court declined to exercise emergency jurisdiction and that the matter be deferred to the Supreme Court of British Columbia. Yeah, there's other things in here in terms of what they believe their grounds are, but that's all that's before me in terms for the request of de novo.
And Your Honor, if I might interject, the day following our hearing before Judge Lee, Lorraine Butt turned around, filed an entirely—
Again, Judge, she is testifying
I
to
am
you.
not testifying,
She's
Your
going
Honor.
to—
I am bringing matters to this court's attention, and I have the absolute right to do that.
Hold
be
on.
an attorney or she's going to be a witness.
I'm only entertaining the de novo appeal. Anything else you all say, I'm gonna cut you off every single time. I do nothing
Very
to
good.
this hearing. In order to keep a clean record, we have to stay on track.
Yes, ma'am.
Okay. So, Attorney O'Vera, would you like to make an opening statement at this time?
No, Judge, I'm going to waive opening.
Did you catch that? This judge is not playing around. She's already warning everyone that if they drift off topic, she'll cut them off. And honestly, with how messy this case is, that might happen a lot. Who do you think will get scolded next, the attorney or the witness? Comment below.
All right. Attorney, am I saying it right, Ryder?
Ryder, yes, ma'am. Yes, ma'am.
Would you like to make an opening statement at this
I
time?
would, Your Honor. Simply put, this is a Hague Convention case. Ms. Butt has wrongfully retained 3 children aged 5 and under.
I'm going to object, Judge. She is going into matters that are not before the court.
Sustain.
Your Honor, we have findings out of the Supreme Court of British Columbia that these parties are habitual residents of Canada, as are their children. The Canadian Supreme Court has superior jurisdiction of all matters pertaining to this case. And given the impact of the Hague Convention,
again, Judge, I'm going to
looking
object because she's going into matters that are not before the court. We're not hearing the Hague Convention case.
Sustain.
Your Honor, if I may call my first witness.
You may proceed.
I
Thank
think I was the petitioner.
O'Vera is the movement. Attorney O'Vera is the movement.
All right. Sorry. Go ahead.
Attorney O'Vera?
I'm going to call my client, Ms. Butt. And Judge, just for clarification, how much time do we have?
Well, I have 15 minutes aside.
Okay. Ms. Butt, state your full name for the court.
Lorraine Shiza Butt.
Okay, and you are the petitioner in this case, correct?
Correct.
And you brought a case for the divorce, orders regarding your child, and you also brought a separate action for a protective order, correct?
Correct.
Are you the victim of family violence, ma'am?
Correct. Yes, I am.
13G, 13.1. Objection calls for
When
legal.
was the last incident of family violence?
Saturday, June 21st, 2025.
Your
Hold
Honor,
on 1 second. There was an objection made. Attorney Ryder,
yes, Your Honor. This is hearsay, Your Honor.
sustain.
And just like that, the case shifts from procedure to pure emotion. This is the moment where the real allegations hit the courtroom: violence, children present, threats. No matter where you stand, this is heavy, and the judge knows it.
I asked when was the last incident of family violence, Judge? Is that what you're sustaining?
She said, no, well, then there were two objections made. I just didn't catch the second one. The first one was, are you the victim of family violence? That's not the last question you asked, right, counsel?
No, I asked when was the last incident of family violence?
Okay, so that's what while you were still speaking, Attorney Ryder was making the objection. So let's go back. The first question was, are you a victim of family violence? She said, correct, I am. Attorney Ryder objected to calls for a legal conclusion. I'm overruling that one. And then the next question was, when was the last incident of family violence? And she was answering Saturday, June. Attorney Ryder, your objection was hearsay?
Yes, ma'am.
Okay, she didn't finish answering the question. So, ma'am, when was the last incident of family violence?
Saturday, June 21st, 2025.
Okay. Attorney O'Leary, you may ask your next question.
So, ma'am, what was happening this day between you and your husband?
We recently just had our third child, May 22nd of this year, and we were planning a party. And I'm discussing finances, as was he, in our children's bedroom. And I gave my 2 cents in terms of finances and how we do not have an X amount of whatever it may be in terms of vendors or whatnot. This has been a past issue as well, as he does not like it if I give my ideas to him.
Objection narrative.
Sustain.
Ma'am, let me ask another question.
Sure.
So I need you to say exactly what happened between you and your husband when the family violence occurred.
Leading.
Overall,
Ma'am, go ahead.
Sure, I made a financial suggestion. He did not like anything that I had.
Notice what's happening here: objections are being thrown like confetti. Hearsay, legal conclusion, leading, narrative. This is classic courtroom chaos. But the judge is actually doing something very smart. She's isolating each objection one by one. That keeps the record clean and prevents an appeal nightmare.
Stated that he was going to kill himself. And he stated that he will kill me and the children, and followed up.
Objection, Your Honor, to the extent that this is hearsay as to what my client might have said.
That's not hearsay, Judge. That's an admission by a party opponent.
overall.
He pushed and slapped me and the children while coming back to the children's bedroom with a knife in his hand. Proceeded to say that he's going to kill himself because he cannot take this anymore.
Objection narrative.
He proceeds to close the door.
Hold on, ma'am. The judge has to rule on the objection.
Sure.
Sustain. Attorney O'Leary, you may ask your next question.
Did he threaten the children in any way?
He did. He said he's going to cut up the children.
Objection, hearsay. This is, again, an out-of-court statement offered to prove the truth of the matter asserted within the statement, Your Honor.
This is an admission by a party opponent.
She's saying her husband said it, right? Who's present?
Yes.
Okay, overruled.
Go ahead, ma'am.
He stated he's going to cut me and the children, and stated that if anyone comes near him, he will kill me and the children.
And were the kids present during the time that he made these statements?
Yes, they were. Yes.
Was he holding the knife at the time that he made these statements?
Yes.
And this exhibit that I have up as marked as Exhibit 17, does that talk about the issues you were having that day?
Yes.
And in this exhibit, he says he's done and he can't wait to die, correct?
Correct.
He also says that he's scared that he will kill himself, correct?
Correct.
At any point, ma'am, did he write an exhibit to you saying that he was worried about killing somebody else?
Yes, correct.
Do you remember if it was
Objection leading, Your Honor.
Sustain, don't leave.
Okay, ma'am. Has he ever threatened anybody else aside from you and the children?
Objection, speculation on the part of the witness.
It's not.
Attorney Vera rephrase your question.
Ma'am, has he ever threatened anybody else?
He has threatened the children.
Okay, has he ever threatened a third party aside from yourself and the children?
Objection leading.
That's not leading, Judge. I'm asking if he's done it.
It's absolutely leading. It calls for the answer within the question, Your Honor.
I already ruled. I said overruled.
You can answer, ma'am.
He stated he would kill himself.
Did he say?
Objection, excuse me. Objection, non-responsive, move to strike.
Which part?
The question was as to a third party. The response was specific as to Mr. Jutt. It was non-responsive.
I'm reading. He stated that he would kill himself, and the Attorney O'Vera started to say, "Did he say?" So, were you moving to strike what Attorney O'Vera was getting ready to ask?
No, ma'am. What I heard with my old ears, I thought, was that Ms. Butt had volunteered a response as to Mr. Jutt specifically, rather than as to threats to third parties, which was the question.
I didn't catch. That's not what I catch.
All right.
May I proceed, Judge?
Yes.
Okay, so here on the screen, ma'am, it even says exactly, I don't know what else I'll be able to do. I might kill someone. Do you remember that?
Yes, I do.
I don't want to be here. I don't want to be this person, correct?
Correct.
Was this sent to you immediately before or after the incident where he picked up the knife and started threatening you?
After the incident.
Have you ever had any problems with your husband to this magnitude before?
No.
How long have the issues between you and your husband been going on?
Ever since we've gotten married.
So, ma'am, has he been violent with you before June the 21st, 2025?
Yes, he has.
Do you remember how many times he's been violent with you?
A lot, a lot.
Objection, non-responsive.
2 pages long.
Second, I think the reason why I'm not catching it is because you all are talking at the same time.
It's my camera or my application is lagging really bad, and I think that might be part of the reason.
Okay, so what I see is question, do you remember how many times he was violent with you? And her response was a lot, like a lot. Attorney Ryder, you objected to which part?
Your Honor, she also responded like 2 pages long, and I was objecting to the response being non-responsive.
Only non-responsive part I could grant is after she said a lot. And she said,
yes, ma'am. That's it.
So sustain.
Okay, Judge, Ms. Yanis is going to help me with the exhibits because for some reason they are not opening on my computer.
Okay.
So, ma'am, I'm going to ask Alex to bring up what's been marked as Exhibit 11. And Exhibit 11 is copies of some pictures. You took those pictures, correct?
Correct.
I'm going to object to the fact that we don't have any dates on these pictures. We have no idea.
They've already been admitted, and these objections have been made.
The all the objections prior to at the start of the hearing, 1 through 19 were admitted for petitioner, and respondents 1 through 53 were admitted.
Okay. Your Honor, I would still respectfully request some timeline as to when the what date is this tied to?
She can use her time on that, Judge, and if she's interrupting me consistently, is this gonna count against my time?
No, what I do is start the other person's time whenever you object.
Okay. May I proceed, Judge?
Yes.
Okay, so ma'am, you see the pictures, correct?
Correct.
And tell me when you took these pictures.
June 28th, 2022.
And ma'am, what happened between you and your husband that time that you came out with these bruises?
Another verbal argument between us.
What did he do to you?
He pinned me to the
Objection,
wall.
Your Honor, leading.
That's not meeting, Judge.
Overruled. She asked, what did he do to you?
What did he do to you, ma'am?
He pinned me to the wall and didn't like that I was discussing something and was proceeding to literally twist my arms and dig his nails into my arms.
Were the children present during this time?
Yes, they were.
Did they witness it?
Yes.
Did you call the police?
I did a week later due to another incident.
Okay, did you make a report with the police about another incident?
This is one of the biggest turning points so far. The photos, the dates, the timeline, this is the kind of evidence judges rely on heavily. But look at the strategy. The opposing attorney immediately questions the dates and validity. Why? Because if the timeline crumbles, the entire allegation history starts looking shaky. Let me know, do you think these pictures tell the full story?
July 7th, 2022, I made the report.
Okay. Bring up the video, number 12. Is this one of the reports that you made? The one that's marked as Exhibit 9?
Yes.
Okay, ma'am, and why did you call the police at this time?
Your Honor, may I take the witness on voir dire?
Yes.
I will ask that Ms. Yanez move down to page, actually, the first, second, third,
Hold on.
fourth page, which is actually marked page 2 of 3 at the bottom. It says restricted at the top. It says Larab advised she wants to be talked to about their ongoing verbal arguments.
Hold on 1 second. Can you all hear me?
Yes, ma'am.
Yes.
Hey, hold on 1 second. I'm thinking there's a lag on this camera too. Can you all hear me clearly?
Yes, ma'am.
I can hear you, Judge.
All right. I think it's a delay on using this camera too, but we'll push through. Attorney Ryder, you may proceed.
Thank you, Ms. Yanez. Would you please move down to page, what would be number 4, moving down 2 more pages?
Judge, I'm going to ask why is she taking her on voir dire, because this seems more like cross than voir dire.
Well, Your Honor, we're making representations about this police report, and I think it needs to be clarified, and that's what I'd like to do.
That would be on cross, Judge.
Specifically, what would you be taking her on voir dire about with the police report?
So the police report indicates, was any offense committed during this incident? Response, no. It is, were the children present? Yes. On page 3, it indicates that Larabe simply wishes to have someone at the police department talk to her husband about verbal disagreements that she has had with her husband. There is nothing here that talks about physical violence in this police report. This is being represented as a report of physical abuse. There is nothing speaking to physical abuse in this police report. There is, she was offered information about intimate partner violence. She refused it. So again, if we're speaking in terms of alleged abuse, this court needs to understand that this is being blown way out of proportion.
And Ms. Ryder is just arguing, Judge, instead of actually making an objection or giving you a reason to take the witness on voir dire. Everything she just said is on cross.
And I'm inclined to agree with Attorney O'Vera, Attorney Ryder. Everything you just said would be something that you would question her about on cross-examination.